Good day, everyone. We are Group 7 from EPPA 2823 Business Law. My name is Zhang Xiaoyuan, and with me are Liu Xuanyu, He Wanhua, Zhang Yun. Today, we will explore an issue that still affects workplace worldwide, the unfair dismissal of pregnant workers. We will break down the legal framework, review real cases, and suggest ways Malaysian law can better protect expecting mothers. First, let's look at the incidents that sparked our research. So let me present about the problem statement. Pregnant employee dismissed. An employee informs her manager she is pregnant. Barely a month later, she receives a termination letter citing company restructuring under Malaysia's Employment Act 1955, Section 41A. Dismissal on the basis of pregnancy is prohibited. So, is this a genius restructuring or a concealed act of discrimination? This single event raises critical legal and ethical questions, and it forms the core of our study. And why does this matter? This matter goes far beyond the one individual case. First, it is a human rights and gender equality concern. Every worker deserves job security, especially during pregnancy. Second, unfair dismissal discourages women from staying in the labor force. Malaysia's female participation rate is only about 55%. Third, protecting pregnant employees is part of a firm's legal duty and corporate social responsibility. Both themes we examine in business law, ignoring these dimensions risks legal penalties, reputational damage, and a loss of valuable talent. So, for research motivation and objectives, our motivations is twofold: to raise public awareness of employee rights and to test how effective the current laws protect pregnant workers in practice. We set three objectives. One, analyze key provisions in the Employment Act 1955 and the Industrial Relations Act 1967. Two, investigate real-world cases like the one we just described to see how those laws are applied. Three, proposed legal and policy improvements for stronger enforcement. With that roadmap, let's move into Part B and examine the legal framework.
Hi everyone, let's start with the basic question. Who counts as a worker in the UK? British law actually uses three labels. Employee gets a full menu of rights. Worker gets a smaller set. Self-employed almost none. Sounds messy, right? The Uber Aslim case in 2021 shows how messy it is. The Supreme Court said Uber drivers are workers. That means they must get minimum wage and paid holidays. But they still can't claim unfair dismissal or redundancy pay. Now, hop over to Deliveroo. Their careers are still STEM self-employed, so they miss out on even the basics. Same gig, different badge, totally different protection. That's the fragmentation we are talking about. Let's see what each badge actually unlocks. If you are a worker, you're received by the National Minimum Wage Act, so at least you get a floor wage. You are also under the working time regulations, meaning paid leave and rest breaks. If you want sick pay, unfair dismissal, or redundancy money, sorry, that's for employees only. Parliament keeps promising fix. Two new acts, one on predictable hours, one on fair tips, have passed, but they are still not active. They're like apps on your phone that say coming soon until they switch on. The hole's still open. Even when rights exist, getting them is another battle. Status is judged case by case in court. Litigation is slow and pricey. Drivers can't afford years of appeals. Regulators are scattered. Each MRC checks wages, each HSE looks at safety, but no single office plays the gig setter end to end. And gig workers struggle to unionize, so their collective voice is weak. Bottom line, many drivers or riders are one illness away from zero income because they still have no sick pay or dismissal protection. That's why our issue matters. Same streets, same work, completely different safety nets.
Hi everyone, I'm Shane, and my matching number is 8199942, and I like to talk about some real-life examples of unfair dismissal and discrimination at the workplace, as well as share my own reflections on what we've learned in this course. One of the most common issues we found while doing this project was that many employees are dismissed for vague reasons like poor performance or attitude problems, which are often just excuses to get rid of them. In some cases, especially involving women, we saw dismissal happening shortly after the employer found out the employee was pregnant. According to our courses, this kind of termination is considered unfair unless it falls under very limited exceptions, as stated in Section 41A of the Employment Act 1955. And I like to share one example that came up during our research. There was a female employee who was let go just 1 month after she informed her manager of her pregnancy. The company claimed the restructuring as the reason, but she was the only one dismissed in her department. This type of dismissal is very difficult to challenge unless the employee is aware of her rights and has access to legal support. That's why we believe awareness is just as important as the law itself. Under Section 20 of the Industrial Relations Act, the employee could file a complaint within 60 days, but from our perspective, the process is still quite intimidating for many, especially for people working in small companies or on short-term contracts. Even though the law allows them to fight for their jobs or claim compensation, many don't feel confident enough to do so. Another point that really made us think was how discrimination isn't always direct. Sometimes it shows up more subtle ways, like being passed over for promotion or being excluded from meetings or training just because of age, gender, or ethnicity. The new Section 69F of the Employment Act tries to address this by allowing the Director General to step in. But again, people need to feel safe and supported to make such a complaint. Personally, I believe laws like this are absolutely necessary, but they are not enough on their own. Just because something is written in law doesn't mean it always works the way it should. Employers still find ways to go around the system, especially when they know the employee won't challenge them. I think what we need is not only legal protection, but also better enforcement, more education, and a stronger support system for employees. To sum up, this project helped me realize how legal knowledge can empower people. I used to think employment law was only relevant for HR or lawyers, but now I see how it actually affects every working person, including us in future. Thank you.
I will talk about how labor laws in the UK are not protecting in worker equality, especially those in non-standard job like platform work or casual contracts. The article I studied compared two legal cases. First, in the Uber case, in the court help worker by saying they should get minimum wage in the basic right. But in the makeup case, in court used a more technical explanation and said that night care workers did not need to get minimum wage. This shows that the law is not operating in the same way for similar jobs. especially hurt people in the care work, which is mostly done by women, so the law is both farmers and unfair. Now I will share 6 simple policy suggestions. Make worker type clear, like who is an employee, who is self-employed, to stop company from avoiding responsibility. 2. Give basic right to all type of worker, not just full-time ones. That means minimum wage, sick leave, safety at work, and no discrimination. 3. Protect care worker better, because many of them are women and their work is often undervaluable. 4. Make con decision more fair and consistent, so similar jobs get similar protection. 5. Teach workers about their rights and give support from union and social group. 6. Learn from other countries, but also make law that fit in UK school situation. The main idea is labor laws should not just focus on what kind of content you send. It should protect right work and real workers, especially those who are vulnerable. These are the main sources for this topic, including legal case and academic article. The main article is by Bisbee and Zoom from 2024. It talks about the problem for workers' protection in UK law. I also include UK law and cases like the Employment Rights Act and important court decisions like Uber, Iceland, and Minkat Tomlinson Black. Thank you for your listening.